What is consideration? Section number 2. Red tick. When at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to or abstain from doing something, such an act or abstinence or promise is called consideration for the promise. Consideration may consist of either some right, interest, profit, or benefit accruing to one party for forbearance, detriment, loss, or responsibilities given, suffered, or undertaken by other. Legal rules regarding consideration. Consideration must move at the desire of the promisor. Ratic. Consideration must be offered by promisee or third party at the desire or request of promisor. An act done at the desire of a third party is not a consideration. Case law Durga Prasad versus Baldev. Consideration may move from promisee or any other person. Ratic. Consideration may proceed from the promisee or any other person who is not a party to the contract. There can be a stranger to a consideration but no stranger to a contract. Case law Chinnaya versus Ramaya 1882. Executed and executory consideration. Third point I. Consideration which consists in the performance of an act is said to be executed. When it consists in a promise, it is said to be executory. Consideration may be past, present, or future. If services being rendered in past at the request or desire of promisor, the subsequent promise is regarded as an admission that past consideration was not gratuitous, was not gracious, gratuitous. Consideration need not be adequate. It need not be ये इसके ऊपर एड ठीक है. It need not to it need not be approximately of equal value with the promise for which it is exchanged, but it must be something which the law would regard as having some value. Something in return need not be equal to something given. If a consent is freely given, will not be void merely because consideration is inadequate, but if it is less and other that his consent was not free, then this inadequate consideration can be taken as evidence in performance of what one is legally bound to perform. Performance of an act by a person who is legally bound to perform, bound to do, or such a promise, provided it is not opposed to public policy, is a good consideration. Consideration must be real and not illusory, to which the law attaches some value. If it is legally or physically impossible, it is not considered valid consideration. Consideration must not be unlawful, immoral, or opposed to public policy. Only presence of consideration is not sufficient. It must be lawful. Anything which is immoral or opposed to public policy also can't be valued as valid consideration. Sued by a third party to a contract. Ratic. Consideration for an agreement may proceed from a third party, but the third party can't sue on contract. Only a person who is party to a contract can sue on it. Thus, a stranger to consideration is a valid and is different from a stranger from stranger to a contract. Stranger to contract can't sue is known as a doctrine of privity of contract. It is, however, subject to certain exceptions. In the case of trust, a beneficiary can enforce his right though he was not a party to contract between the settler and the trustee. In the case of family settlement, if terms of settlement are reduced into writing, the members of family who originally had not been parties to settlement may enforce the agreement. In case of certain marriage contracts slash arrangements, provision may be made for benefit of a person. He may file the suit though, though he is not a party to the agreement. In the case of assignment of a contract, when benefit under a contract has been assigned, assignee can enforce the contract, but such assignment should not involve any personal skill, acknowledgement, or estoppel, where promisor by his conduct acknowledges himself as an agent of third party, it would result into a binding obligation towards third party. In the case of covenant running with rent, person who purchases land with notice that the owner of land is bound by certain duties affecting land, covenant affecting the land may be enforced by a successor of the seller. Contracts entered into through an agent. Principal can enforce the contracts entered by his agent where agent has acted within the scope of his authority and in the name of principal. Validity of an agreement without consideration. Section number 25, red tick. Agreement made without consideration is void. Contract may be enforceable when consideration is there. However, there are certain exceptions to this rule. In following cases, agreement though made without consideration will be valid and enforceable. First point, natural love and affections. Following conditions must be fulfilled. It must be made out of natural love and affections between the parties. Parties must stand in near relation near relationship to each other. It must be in writing. It must also be registered under the law. Second point, compensation for past voluntary services. Promise to compensate wholly or in part. A person who has already voluntarily done something for the promisor is enforceable. The following essential factors must exist. The services should have been rendered voluntarily. The services must have been rendered for the promisor. The promisor must be in existence at the time when services were rendered. The promisor must have intended to compensate the promisee. Promise to pay time bar debt. That tick. Where a promise in writing signed by person making it a authorized agent is made to pay a debt barred by limitation, it is valid without consideration. Agency. No consideration is necessary to create an agency. Section number 185. Completed gift. In case of completed gifts, the rule no consideration, no contract does not apply. Gifts does not require any consideration. Bailment. No consideration is required to affect the contract of bailment. Section number 148 defines bailment. No consideration is required to affect a contract of bailment. Charity. If a promisee charity red tick. If a promisee undertakes the liability on the promise of the person to contribute to charity, there the contract shall be valid. Case law Kedarnath versus Gori Muhammad. 2 minutes break. Introduction. Agreement in order to be a contract must satisfy the following conditions. Parties must be competent to contract. It must be made by the free consent of the parties. It must be made for the local parties to make a contract. Every person is competent to contract. Who? Section number 11. First point, has attained age of majority. Second point, is of sound mind. Third point, is not disqualified by any law to which he is subject to. Age of majority. Every person domiciled in India shall attain the age of majority on the completion of 18 years of age and not before. No person less than that age, even by a day, would be a minor for the purpose of contracting. Law relating to minors agreement / position of minors. Void ab initio, ratification, beneficiary, plead minority, necessaries, guardian, specific performance, insolvency, partnership, agent, parents / guardian, joint contract, guarantor, shareholder, liability for torts. Contract made with or by minor is void ab initio. Minor is not competent to contract and any agreement with or by minor is void from the very beginning. Case law Moholi BB versus Dharmodas Ghose 1903. No ratification after attaining majority as the original agreement is void ab initio and a void agreement can never be ratified. Minor can be a beneficiary or can take benefit out of a contract. Though minor is not competent to contract, nothing in the Contract Act prevents the minor from making the other party bound to him. Thus, a promissory note duly executed in favor of a minor is not void and can be sued upon by him because he, though incompetent to contract, may yet accept a benefit. Minor become partner in a partnership firm, however, he must to the benefits of partnership section number 30 Partnership Act 1930. Minor can always plead minority order to do so even where he has taken any loan or into entered into any contract by falsely representing that he was major. Rule of estoppel can't be applied against a minor, that is, he can plead his minority in defense. Liability for necessaries, section number 68, green tick. Claim for necessaries supplied to minor or to any other person whom such a minor is legally bound to support is enforceable by law. But a minor is not liable for any price that he may promise never for more than the value of the necessaries. There is no personal liability of minor, but only his property is liable. To render minors estate liable for necessaries, two conditions must be satisfied. Contract must be for goods reasonably necessary for his support in life. Minor must not have a already sufficient supply of these necessaries. Necessaries mean those things that are essentially needed by a minor. They can't include luxuries or costly or unnecessary articles. Necessaries extended to all such things as reasonable persons would supply to an infant in that class of society to which the infant belongs. Expenses on minors' education, funeral ceremonies come within the scope of necessaries. Contact by guardian, how far enforceable? Though a minor's agreement is void, his guardian can enter into a valid contract on minor's behalf, where guardian makes a contract for minor which is within his competence and which is for the benefit of minor. There will be which the minor can enforce, but all contracts made by guardian on behalf of a minor are not valid. For instance, a guardian of a minor has no power to bind the minor by a contract for the purchase of immovable property, but a contract entered into by a certified guardian of a minor with the sanction of court for sale of minor's property may be enforced. No specific performance. A minor's agreement being absolutely void, there can be no caution for specific performance of such an agreement. No insolvency. Minor can't be declared insolvent as he is incapable of contracting debts and dues are payable from the personal properties of minor and he shall never be held personally liable. Partnership. Minor being inclined to contract can't be a partner but under section 30 of Indian Partnership Act he can be admitted to the benefits of partnership. Minor can be an agent. A minor can act as an agent, but he will not be liable to his principal for his acts. A minor can draw, deliver, and endorse negotiable instruments without himself being liable. Minor can't bind parent or guardian. Green tick. In the absence of authority expressed or implied, an infant is not capable of binding his parent or guardian. Even for necessaries, parents will be held liable only when the child is acting as an agent for the parent. Joint contract by minor and adult will be liable on the contract and guarantor for a minor. In a contract of guarantee, when an adult stands a surety for a minor, then he bracket में adult is liable to third party as there is direct contract between surety and the third party. Minor as shareholder. Minor being incompetent to contract can't be a shareholder of the company. If by mistake he becomes a member, company can rescind the transaction and remove his name from register. But a minor may, acting through his lawful guardian, become a shareholder by transfer of a transmission by transfer or transmission of a fully paid shares to him. Liability for torts. Tort is a civil wrong. Minor is liable in tort unless the tort in reality is a breach of contract. Thus, if minor borrowed a horse for riding only, he was held liable when he lent the horse to one of his friends who jumped and killed the horse. Similarly, minor was held liable for his failure to return certain instruments which he had hired and then passed to a friend. B point. Person of sound mind. Section number 12. A person is said to be of sound mind if at the time when he makes a contract is capable of understanding it and of forming a rational judgment as to its effect upon his interests. Person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. Person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. Position of unsound mind person making a contract is void. C point. Contract by disqualified persons. Besides minors and persons of unsound mind, there are also other persons who are disqualified from contracting partially or wholly so that the Contracts by such person are void. Incompetency to contract may arise from political status, corporate status, legal status. The following persons fall in this category: foreign sovereign, foreign sovereigns and ambassadors, alien enemy, corporations, convicts, insolvent, etc. Second point: free consent. Definition of consent, section number 13. Two or more persons are said to consent when they agree upon the same thing in the same sense. Parties are said to have consented when they agreed upon the same thing in the same sense. When parties make some fundamental error as to nature of transaction, all person dealt with the or subject matter of agreement, they have not agreed upon same thing in same sense, and there can't be a consent. A contract can't rise in the absence of consent. Consent may be free or not free. Only free consent is necessary for the validity of a contract. Definition of free consent, section number 14. Consent is said to be free when it is not caused by coercion, section number 15, or undue influence, section number 16, or fraud, section number 17, or misrepresentation, section number 18, or mistake, subject to section number 20, 21, and 22. When consent to an agreement is caused by coercion, fraud, misrepresentation, or undue influence, the agreement is a voidable contract. The agreement is a contract voidable at the option of the party whose consent was so caused. When the consent is vitiated by a mistake, the contract becomes void. First, coercion. Section number 15, meaning. Green tick. Coercion is committing or threatening to commit any act forbidden by Indian Penal Code, or unlawful detaining or threatening to detain any property, mm, prejudice of any person whatever, with the intention of causing any person to enter into an agreement. It is not necessary that coercion must proceed from a party to contract. No subject of the coercion must be the other contracting party. It may be directed against any third person. Effects of coercion, section number 19. Voidable at the option of party whose consent was so obtained. Person to whom money has been paid or anything delivered under coercion must repay or return it. Section number 72. Threat to commit suicide. Whether is it coercion? Suicide through forbidden by Indian Penal Code is not punishable as a dead man can't be punished. But section number 15 declares that committing or threatening to commit any act forbidden by Indian Penal Code is coercion. Hence, a threat to commit suicide will be regarded as coercion. Undue influence, section number 16, red tick. Meaning, contact is said to be induced by undue influence where the relations subsisting between parties are such that one of the parties is in a position to dominate the will of the other, and he uses that position to obtain an advantage over the other. Essential ingredients under this provision are relation between the parties. First point, a person can be influenced by other when a near relation between the two exists. Second point, position to dominate the will. Red tick. Relation exists in a manner that one of them is in a position to dominate the will of other. A person is deemed to be in such position in the following circumstances: real and apparent authority, where a person holds the real authority over the over other, Example, master and servant, doctor and patient, etc. Fiduciary relationship, where relation of trust and confidence exists between parties. Example, father and son, solicitor and client, husband and wife, creditor and debtor, etc. Mental distress. Undue influence can be used against a person to get his consent on a contract where the mental capacity of the person is temporarily or permanently affected by the reason of mental or bodily distress, illness, or of old age. Unconscionable bargains, where one party is in a position to dominate the will of other, and the contract is apparently unconscionable, that is unfair. It is presumed by law that consent must have been obtained by undue influence. Example, money lending transaction and in gifts. Third point, objective must be to take undue advantage in getting consent of other. Fourth point, burden of proof, where a party to contract decides to avoid the contract on the ground of undue influence, he has to prove that the other party is in position to dominate his will. The other party actually used his position to obtain his consent. Transaction is unfair or unconscionable. If Fifth point, effects of undue influence, section number 19A. Red tick. Contract is voidable at the option of the party whose consent was so caused. Such contract may be set aside either absolutely or upon such terms and conditions as to the court may seem fit. If party entitled to avoid it has received any benefit thereunder. C point. Fraud, section number 17. Definition. Green tick. Fraud means and includes any of the following acts committed by a party to a contract or his connivance or by agent with an intent to deceive another party or his agent or to induce him to enter into the contract. Suggestion Suggestion as a fact which is not true by any person who does not believe it to be true. Active concealment of a fact by one having knowledge or belief of the fact, a promise made without any intention of performing it, any other act fitted to deceive. Any such act or omission as the law specially declares to be fraudulent. The following are the essential elements of the fraud. First point, there must be a representation or assertion and it must be erratic. However, silence may amount to fraud or an active concealment may amount to fraud. Caution. Whether silence is fraud or not. Answer. Silence is fraud in the following situations. There is duty to speak when silence is equal to speech. Second point. Representation must be related to a fact. The third point, representation should be made before the conclusion of the contract with the intention to induce the other party to act upon it. Fourth point, representation or statement should be made with the knowledge of its falsity or without belief in its true or in its truth or recklessly not caring whether it is true or false. Fifth point, the other party must have been induced to act upon the representation or assertion. Sixth point, the other party must have relied upon the representation and must have been deceived. Seventh point, the other party acting on the representation must have consequently suffered a loss. Effect of fraud upon validity of a contract. Red tick. Is caused by fraud. The contract is voidable at option of party defrauded, and he has the following remedies. He can rescind the he can rescind the contract within a reasonable time. He can sue for damages. He can insist on performance of contract on the condition that he shall be put in the position in which he would have been had the representation made been true. Except in the following cases, contract is not voidable. If the party whose consent was caused by silence which amounting to fraud had the means of discovering the truth with ordinary diligence, a fraud which did not cause the consent of the party to agreement. Misrepresentation. Section number 18. Rhetoric. There is a misrepresentation if statement of fact which is false would constitute misrepresentation if the maker believes it to be true but which is not justified by the information he possesses. Where there is a breach of duty by a person without any intention to deceive but which brings an advantage to him. Where a party causes the other party to agreement to make a mistake as to the subject matter even though done innocently. Difference between coercion and undue influence. Rhetoric. Basis by ICA. Nature of action, criminal action, relationship between parties, exercised by whom, enforceability, position of benefits received, distinction between fraud and misrepresentation. Green tick. Basis by ICA. Intention, knowledge of truth, rescission and claim for damages, means to discover the truth. E point mistake. Mistake may be defined as innocent or erroneous belief which leads the party to misunderstand the others. Mistake may be either mistake of law or mistake of fact. Mistake of law. It is further classified as mistake of Indian law or foreign law. Mistake of Indian law. A person can't be allowed to get any relief on the ground that it had done a particular act in ignorance of law. Mistake of foreign law. Such a mistake is treated as a mistake of fact, and the agreement in such a case is void. Mistake of fact. It is of two types: bilateral mistake and second unilateral mistake. Bilateral mistake where both parties to an agreement are under a mistake as to matter of fact essential to the agreement is void. Section number 20. Cases of bilateral mistakes. It can be quality, existence, identity, title, price. It can be quality slash existence slash identity slash title slash price slash quantity of the subject matter. Unilateral mistake. Contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to matter of fact. Section number 22. Third point. Legality of object and consideration. Section number 23. In each of following cases, consideration or object of an agreement is said to be unlawful. First, forbidden by law. Second, defeat the provision. Third, fraudulent. Fourth, injury to person slash property. Fifth, illegal. Sixth, opposed to public policy. When conciliation or object is forbidden by law, acts forbidden by law are those which are punishable under the statute as well as those prohibited by regulations or orders. When consideration or object are of such a nature that if permitted not directly but indirectly it would defeat the provisions of law, agreement is void. When it is fraudulent, Agreements which are entered into to promote fraud are void. The general term injury means criminal or wrongful harm. The object or consideration is unlawful as it involves injury to the person or property of another. Example copyright when consideration is immoral. When consideration is opposed to public policy in the name of public policy, freedom of contract is restricted by law only for the good for the community. Some of the agreements which are held to be opposed to public policy are: first point, trading with enemy; second, stifling prosecution; third, maintenance and champerty; fourth, public offices slash titles; fifth, creating monopolies; sixth, marriage brokerage agreements; seventh point, interference with the justice; eighth point, interest against the obligation; ninth point, consideration law in unlawful in part; trading with enemy, any trade with person owing allegiance to a government at war with India without the license of the government of India is void as the subject is opposed to public policy. Hence, the agreement to trade offends against the public policy by prejudice to the interest of the state in times of war. Stifling prosecution, green tick. An agreement to prevent proceedings already instituted from running their normal course using force tends to be a perversion or an abuse of justice, therefore void. The principle is that one should not make a trade of felony. The compromise of any public offense is generally illegal. However, Indian Criminal Procedure Code provides a statutory list of compoundable offences and an agreement to drop proceedings relating to such offences with or without the permission of the court. In consideration, the accused promising to do something for the complainant is not opposed to public policy and hence valid. Maintenance and champerty granting. Maintenance is an agreement in which a person promises to maintain suit in which he has no interest. Champerty is an agreement in which a person agrees to assist another in litigation in exchange of a promise to hand over a portion of the proceeds of the action. It is unreasonable so as to be unjust to other party, or it is made by a malicious motive and not with the bona fide objective of assisting a claim. Trafficking relation re- Trafficking relating to public offices and titles. Red tick. Agreement to trafficking in public offices opposed to public policy as it interferes with the appointment of a person best qualified for the service of the public. Public policy requires that there should be no money consideration for the appointment to an office to which the in public is interested. Following are the examples of agreements that are void. Agreement to pay money to a public servant in order to induce him to retire from his office so that other person may secure the appointment is void. An agreement to procure a public recognition like Padma Vibhushan or the award. Agreements tending to create Agreements tending to create monopolies are opposed to public policy and therefore negotiate marriage for reward, which is known as a marriage brokerage contract is void as it is opposed to public policy. Note: Marriage Bureau only provides information and does not negotiate marriage for reward, therefore, it is not covered under this point. Interference with the court of justice. An agreement whose objective is to induce any judicial officer of the state to act partially or corruptly is void as it is opposed to public policy. Interest interest against obligation. The object of such agreements is opposed to public policy consideration unlawful in part. If any part of a single consideration for one or more objects or any part of any one of the several considerations for a single object is unlawful, the agreement is void. There is no promise for a lawful consideration if there is anything illegal in a consideration, which legal part of a contract can be severed from it. The bad part may be rejected and the good one can be retained. But where the illegal part cannot be severed, the contract is altogether void. Fourth point, expressly declared void agreements made by incompetent parties. Section number 11. Agreements made under bilateral mistake of fact. Section number 20. Agreements with the consideration or object of which is unlawful. Section number 23. Agreement the consideration or object of which is unlawful in parts. Section number 24. Agreements made without consideration. Section number 25. Agreement in restraint of marriage. Section number 26. Agreements in restraint of trade. Section number 27. Agreement in restraint of legal proceedings. Section number 28. Agreement the meaning of which is uncertain. Section number 29. Wagering agreement. Section number 30. Agreement to do impossible acts. Section number 56. Note point number 1 to 3, 4, 5, 9 already discussed. Point number 11 will be discussed in chapter number 5. Sixth point, agreement in restraint of marriage. Section number 26. Every agreement in restraint of marriage of any person other than a minor is void. So if a person being a major agrees for good consideration not to marry, the promise is not binding and considered as a void agreement. Agreement in restraint of trade person by which any person is restrained exercising a lawful profession, trade, or business of any kind is to to that extent void. But this rule is subject to following exceptions. Where a person sells the goodwill of a business and agrees with the buyer to refrain from carrying on a similar business within specified local limits so long as the buyer or his successor in interest carries on a like business therein. Such an agreement is valid. The local limits must be reasonable. If an outgoing partner makes an agreement with the continuing partner that he will not carry on any business similar to that of the firm within a specified period or within specified local limits, such an agreement, though in agreement between partners not to carry on competing business during 1932, but an agreement of service by which an employee binds himself during the term of his agreement not to compete with his employer is not in restraint of trade. Agreement in restraint of legal proceedings, section number 28, that is a contract through court or which abridges the usual period for starting legal proceedings. A contract of this nature is void. However, there are certain exceptions to this rule. A contract by which the parties agree that any dispute between them in respect of any subject shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable is a valid contract. Similarly, a contract by which the parties agree to refer to arbitration any caution between them which has already arisen or which may arise in future is valid, but such a contract must be in writing. The meaning of which is uncertain. Section number 29. It is valid, it is void, but where meaning thereof is capable of being made certain, agreement is valid. Wagering agreement. Section number 30. Agreement by Retic. Agreement by way of a wager. Way of a wager is void. It is an agreement involving payment of a sum of money upon the determination of an uncertain event. Essence of a wager is that each side should stand to win or lose depending on the way of uncertain event takes place. Essentials of a wager. Retic. There must be a promise to pay money or money's worth. Promise must be conditional on an event happening or not happening. There must be uncertainty of event. There must be two parties. Each party must stand to win or lose. Making such agreement, parties should forestake. Transactions similar to wager gambling. Lottery transactions. Retic. Lottery is a game of chance and not of skill or knowledge. Transactions similar to wager. Retic. Bracket में gambling. Lottery transactions. Lottery is a game of chance and not of skill or knowledge, where the prime motive of participant is gambling. The transaction amounts to a wager. Even if the lottery is sanctioned by the government of India, it is a wagering transaction. The only effect of such a sanction is that the person responsible for running the lottery will not be punished under the Indian Penal Code. Lotteries are illegal and even collateral transactions to it are tainted with illegality. Section number 294A of Indian Penal Code. Crossword puzzles and competitions. Crossword puzzles in which prizes depend upon the correspondence of the competitor's solution with the previously prepared solution kept with the editor of newspaper is a lottery and therefore a wagering transaction. Crossword puzzles, picture competitions, and athletic competitions where prizes are awarded on the basis of skill and intelligence are the games of skill, and such competitions are valid. According to Prize Competition Act 1955, prize competitions in games of skill are not wagers but provided the prize money does not exceed rupees 1000. Speculative transactions. An agreement or a share market transaction where parties intended to settle the difference between contract price and market price of certain goods or share on a specified day is a gambling and hence void. Horse race transaction where price payable to bet winner is less than 500 rupees is a wager. Transactions resembling with the wagering transaction but are not void. Red tick. Chit fund. Section number 30. In case of a chit fund, a certain number of persons decide to contribute a fixed sum for a specified period, and at the end of a month, the amount so contributed is paid to the lucky winner. Commercial transactions or share market transactions. In these transactions, in which delivery of goods or shares is intended to be given or taken, Some do not amount to wages. Games of skills and athletic competitions, crossword puzzles, picture competitions, and athletic competitions where prizes are awarded on the basis of skill and intelligence are the games of skill, and hence such competition are valid. According to the Prize Competition Act 1955, in games of skill are not wages provided the prize money does not exceed rupees 1000. A contract of insurance is a type of contingent contract and is valid under law, and these contracts are different from wagering agreements. Distinction between contract of insurance and wagering agreement. Basis by ICA, meaning consideration, insurable, interest, indemnity, enforceability, premium, and public welfare. Let's start in 5 minutes. Unit number 4. Performance of a contract is section number 37 means fulfillment of obligations to the contract. Parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed or types. Performance may be actual performance, where the party to a contract has done what he had undertaken to do, or either of parties has fulfilled their obligations within time and manner prescribed. Offer to perform slash attempted performance slash tender of performance. When performance becomes due, promiser offers to perform his obligation, but promisee refuses to accept conditions to be satisfied for the valid tender or attempted performance. It must be unconditional. It must be made at proper time and place. Reasonable opportunity to examine goods. It, it must be for whole obligation. Green tick. By whom a contract may be performed. Section number 40 to 42. Promisor himself. Green tick. If it was the intention of the parties that the promise should be performed by the promisor himself, such a promise must be performed by the promisor if contract involves exercise of personal skill or diligence, all which are founded on personal confidence between parties, must be performed by promisor himself. Second agent, where personal consideration is not the foundation of contract, promisor promisor or his representative may employ a competent person to perform it. Legal representatives green tick. Contract which involves use of personal skill or is founded on personal consideration comes to an end on the death of the promisor unless a contrary intention appears. Legal representatives of deceased promisor are bound to perform, but their liability is limited for the value of the property inherited from deceased. Third persons, section number 41. When promisee accepts a performance from third person, he can't afterwards eh, enforce it against the promisor, although promisor has neither authorized nor ratified the act of third party joint promisors. Section number 42. When two or more persons have made joint promise, then unless a contrary intention appears by the contractor, all such persons must jointly fulfill the promise. If any of them dies, his legal representative must jointly with the surviving promisor fulfill the promise. If all of them die, legal representatives of all of them must fulfill the promise jointly. अब बाकी कल सुबह 5 बजे पढ़ेंगे।